I challenged the orders of trial court impugned order, rejecting the application to get the witness to examine the witness in the court hall, as because several allegations is made by the husband, and the fake report has been brought by the husband in colluding with the forensic science laboratory.
Let's see the impugned order. Please come to the order.
My lordships recollect, I had argued before your lordships regarding adducing of evidence through the video conferencing mode, where the DNA test was acknowledged by the director. My lordship said there is no positive order as such pass. Therefore, we'll direct the completion of the trial within 6 months, and, which is the case.
My lord, what happened in this case, my lord? The application is filed for consideration of 112 of Evidence Act, my lord. As could be, the husband has been unequivocally admitted that he is along with the wife, even give birth to the child. Till then, give birth to the child. Thereafter, only the relationship with his wife.
Application is filed by respondent seeking an order to direct the petitioner to secure the witness, forensic scientist who submitted DNA report physically before the court to examine him.
Yes,
What did the court do?
Court has rejected the application.
What is the reason given by the court?
The reasons given in that there are works to the witness. Therefore, you could not able
Please
to be.
come to para number 11.
Please, page number 11.
Para number 11, page number 9. Read from there.
Please.
Yes.
I have gone through the records and pleadings of both the parties. Petitioner has filed this petition seeking the decree of divorce on the ground of cruelty under Section 13(1)(a) of Hindu Marriage Act. In the petitioner has contended that the respondent has avoided the physical relationship with him. Respondent used to speak with another person on mobile phone daily for a couple of hours without fail. And when the petitioner inquired, it is the facts of the case, my lord. And the respondent used to hide the mobile phone.
No, we'll understand.
And never shared her mobile phone number with the petitioner and his family members. It further stated that there was no cohabitation and excess between the couple till 2012-2015. On 6/1/2016, the respondent stated that she is suffering from the stomach pain. And when she was taken to hospital, the doctor was confirmed that the respondent was pregnant for 2 months, 3 weeks. Since there was no cohabitation or excess with the respondent for last 6 months, he inquired the respondent about pregnancy. For that, respondent threatened to commit suicide if inquired about the pregnancy. Hence, the petitioner has strong doubt on the respondent leading adultery life. All these allegations are denied by the respondent in the objection statement. But when the petitioner has filed application for DNA test of the child, petitioner and respondent has given no objections, and accordingly, DNA test was conducted at CFS Central Hyderabad. Report is received from the CFS Central Hyderabad through register post. Now, the order considered for the report of CFS Central Hyderabad. Petitioner intended to examine the forensic scientist who issued the DNA test report. The witness summons was issued to the.
Yes, I've seen. What's wrong with the order?
Pardon?
What is wrong with the order?
My lord, what happened in this case, my lord? The fake report as brought by the husband, the petitioner, along with the petition itself, my lord, without taking the blood. Therefore, the respondent has immense faith over the husband that the child was born out of the married relationship with the husband petitioner only. That's why so much of confidence only, she has given no objections to get the test. So that test report has been malifiedly bring by the husband petitioner in colluding with the officials. Therefore, the petitioner,
what is a party who is in Bangalore? Yes. What the forensic department of Hyderabad? What is how can he manipulate?
My lord, my lord, the mother has no rights to draw the blood from the child, my lord. So that it is against the Article 21 of the Constitution, my lord.
Then you examine him.
My lord, what happened in this case on 19/9/2024, mechanically looked into these judgments, my lord. What I brought before this honorable court. What I brought before this honorable court in Jianka case also rendered by a division bench of Justice Madam Nagaratna Madams. There also they have been held that the child blood cannot be taken.
This is not, we are not on the point. We are on a point. An application that is filed by you seeking to examine so-and-so was dismissed. Now we are not going on to the point whether the said report or whether the sample can be collected or not.
By all right, but on the day of 19/9/2024, when the date is fixed for the taking the evidence of the expert through VC on 19/9/2024, this petitioner has filed the application for adjourn the case because the advocate is not available, because he is coming from the Rani Bennur, nearly about 46 kilometers to the Davangere. That is one thing, my lord. Where the court has been recorded the evidence of the expert, my lord, by delinking on so many times and low voice and a murmuring sound. And as such, my lord, on the imagination, the trial court has been being recorded the evidence of the
Please
petitioner.
read, what is the order? There is no order against you in this.
Yes, no, not that, my lord. Because as such, I am incumbent to cross-examination because their advocate is age of 70 years. He could not able to be cross-examination for lengthy over for 2 hours or 3 hours, my lord. That's why, my
The
lord.
video conferencing rules and
My lord, there,
and that is specifically for all these experts.
Hello,
They
ma'am.
will not waste their time coming to the court every time.
Your Honor, kindly see in the gazette, in the documents, I produced I produced the document at serial number 2, wherein in the 6.2, my lord, any proposal to move a request for a video conference should be first be discussed with the other party or parties to the proceedings. There, they have not taken any consent in this case, my lord. And more so, my lord, further in this case, there is no any, moreover, it is a civil case, my lord. It is a civil case. They are sleep over for length over 5 to 6 years. Now they want to be examined at earliest in order to get the report to be admitted and they take in favor of the petitioner.
Then the court has to think that you are trying to come over, you are filing these petitions only to drag on the proceedings, nothing else.
No, not my lord, not my lord.
Yes, it is.
Even,
Yes.
no, that is not so, my lord. That is not so. We are ready for.
What do you want? What do you want?
Why I want the witness to come
No,
before.
you can't compel the witness to come
No,
to
no.
Bangalore.
Yes, because they orders in the first judgment in the Deepak versus Ramesh case,
Yes.
where, my lord, in the par number 13 of the judgment, my lord, the right to lead evidence in pivotal to fair trial and partakes of the character of the natural justice and fair play. No doubt, where a party is unconsciously indolent, the court may put its foot down and close the right of the party to lead evidence in physical. Moreover, Your Honor, kindly see the person who is coming for to give evidence. He is not in remote area, my lord. He is in Hyderabad, my lord. You would have very hamper opportunity to come over to the Davangere by flight over, and there the expenses is ready to bear by the parties. Now there I will suffer because if at all this honorable court is not pleased to be allow this petition to get the witness in the court hall to cross examination, because on several things, on moreover 112 of Evidence Act is there, and moreover in the evidence itself, Your Honor, in CRB 61/18, he unequivocally admits that he has made all Shanti Puja, etc. As because son is born in a Mula Nakshatra, why he has done the all Puja and etc. My lord.
You should ask him.
That's why, my lord. All
He has
things,
done all that.
all
You should
things
ask
should
him.
be looked into
Yes,
to
yes.
save the allegation
Yes.
to prevent the allegations, my lord, made against the wife
Yes.
by bringing a fake report along with the petition.
Yes.
He has filed the petition along with the petition, a
Yes,
fake
yes,
report
yes.
also. That's why, my lord, the respondent wife has completely doubt over this husband petitioner in order to get this report against the wife respondent, my lord. That's why, my lord, it is a very important role is to be taken place in this case, my lord.
MC number 306 of 2019, where an application is filed under section 151 CPC, dated 9th September 2024. The wife is before this court. The respondent herein, who is the husband, had filed the MC 306 of 2019, seeking annulment of marriage.
Yes, sir.
Seeking
These are
annulment of
dissolution
the
of
marriage. In the case of the husband, that the wife is living in adultery and she had extramarital relationship with other person. And there was no cohabitation and the child is not born to him. He is disputing the legitimacy of the child. And earlier he has filed an application for DNA test, for which the wife has given no objection for the DNA test, and accordingly, the report is also placed before the court. At that point of time, this application came to be filed by the wife, seeking an order to direct the husband to secure the witness, forensic scientist who submitted the DNA report physically before the court to examine him. That application is disposed of by way of this order, where the court had dismissed the application to secure the witness physically. However, the office is directed to contact the witness through email about the date and time of his availability through video conference examination. While passing such an order, the court had observed that as no objection was given by the wife, the DNA test was conducted and the report is received from the CFSL Center, Hyderabad, through registered post. In order to consider the report of the CFSL Center, petitioner the husband intend to examine the forensic scientist who issued the DNA test report. The witness summons were issued to the forensic scientist to appear before the court to give evidence, but he submitted his inability to appear physically and has stated that he'll give evidence through video conference. The court observed that the High Court of Karnataka has framed the rules for recording evidence through video conference. There is provision for recording evidence through video conference. Through video conference, witness can be seen and questions can be posed as put in regular court. Respondent wife can put the questions to the witness in respect of objections raised by her to the DNA test. Therefore, by examining the witness through video conference, no prejudice would be caused to the wife. The forensic scientist will be having a lot of work and they'll be busy in preparing reports. If the witness is secured physically, it will cause much inconvenience to the witness and also the department. When rules are framed for examination of witnesses through video conference, no harm would be caused to the wife. And the court felt that the wife has not made out any sufficient ground to secure the witness physically, and accordingly dismissed the application and directed the office to contact the witness through email about the date and time of his availability. Aggrieved thereby, the wife is before this court. Learned counsel for the petitioner has submitted that the DNA test cannot be conducted, and it is contrary to the law laid down by a division bench of this court. He submits that unless and until the forensic expert is physically examined, it will be difficult for the wife to elicit the evidence. Further, it is also stated that the officials, the forensic department have colluded with the husband, and such a fake report is placed before the court. Unless and until it is physically examined, it would cause a lot of hardship to the wife. Learned counsel submits that an opportunity should be given to the wife. A fair opportunity should be given to the wife. Then he had relied on the rules, video conferencing rules framed with the High Court of Karnataka. Basing on this, learned counsel submits that before moving such an application, taking such a decision, no consent was obtained by the respondent, and it is submitted that, viewed from any angle, the order of the court suffers from the irregularity and also causes a lot of hardship, and the same needs to be set aside. Having heard the learned counsel for the petitioner, the submission of the learned counsel that the DNA test cannot be done on the child, that aspect is not cannot be decided by this court in this petition, as the wife had given consent for the same. The test was done. Then coming to the aspect that that unless and until he comes physically, the scientist comes physically to the court, lot of hardship will be caused to him. Also, has no legs to stand. In that regard, it is submitted that the poor quality of video conferencing and other things, which can always be rectified and which can always be brought to the notice of the court. The submission of the counsel with regard to prior intimation to him is concerned. The intimation about his consent for the video conferencing. The witness is an expert. He has nothing to do with the case of the parties. Because of the differences between the parties, if these kind of allegations are made against the experts, nobody will come forward to give evidence. The expert is from Hyderabad. When the court asked him to come personally, he has requested the court that due to his work commitments, it is not possible for him to come. He can reduce the evidence through video conferencing. In those circumstances, the court has felt that it can be done through video conferencing. All the submissions that are made before the court appears to be that on one pretext or the other, the petitioner wife wants to drag on the proceedings. Like if at any point of time, if the video or audio is not clear, the court will be conscious of that and court will take care of it. This court finds no reasons to interfere. Accordingly, the petition is dismissed. Though initially this court wanted to dismiss this petition with cause, however, dismissed without cause.